With this lecture, we are starting the new big topic of the whole course, which is essentially the fundamental principles of international trade. There are not many, which we are going to cover within this particular course, and both which we are going to talk about: most favored nation, MFN, which I'm going to cover today, and national treatment, which will be subject to a separate discussion, are indeed the underlying core of current international trade regulation. So understanding these two principles is absolutely fundamental also for the exam, because clearly the questions during the exam will necessarily relate to the application of MFN and national treatment, as those are the underlying principles. Most favored nation treatment is indeed the most basic obligation that all WTO members have to undertake. It is located in the GATT in the very beginning of the text in Article 1, and we will deal a lot with the text of Article 1 today. I once again invite you to read your own text, not read the text from the slides only. Today you will see how difficult the wording is and how difficult it may be to comprehend it just reading. Therefore, take your time, put the video on pause for a while to read it carefully and understand the essence of the regulation. I will try my best to go slowly so that you manage to understand how the provision is constructed and what it effectively means. Most favored nation treatment, MFN, is the word, is the term that you always come across, not only in international trade law, but also in international investment law. So this is one of the modern underlying legal principles of the overall economic order in any of the institutions that are present there. And most favored nation treatment is something you may come across in your domestic legislations, especially with respect to the treatment of foreign investors. And we need to understand what it effectively means. The name of the provision, most favored nation treatment in Article 1, is not really very helpful for the unprepared reader. You don't really understand what it may mean, most favored nation treatment. But now, going through the text, we will understand the concept, the essence of it. I don't think it will cause any troubles. So the underlying object and purpose of MFN has been worded by the appellate body in EC seal products. They say that it's a fundamental non-discrimination obligation. So once we say non-discrimination, we already have the feeling of what we are going to talk about. MFN Article 1 sets out a fundamental non-discrimination obligation under the GATT. The obligation set out in Article 1 has been described as pervasive, cornerstone of the GATT, one of the pillars of the WTO trading system. So indeed, I could not overestimate this provision, because it is one of the one of the basic provisions that gave life to the whole building of the WTO. That's the basement. And once again, as said, it's a provision that is aimed at the prohibition of discrimination. More specifically, appellate body Canada Autos, the object and purpose of Article 1 is to prohibit discrimination among like products originating in or destined for different countries. So now we already have the feeling what Article 1 will be about. It's prohibition of discrimination between products based on their origin. So if we would take a pencil from, say, China and the identical pencil from Cambodia, these two pencils or pens or whatever, bulbs, take any product you like, should these two products be like, should not be discriminated against, could not be discriminated against. These two products, once we understand that these are the two chairs, should be treated in a similar fashion. So there cannot be discrimination that will be provided by WTO member to product from one country, any privilege that will be given to a product from one country and not extended to the like product or the similar product from the other country. So these are the very basic my attempts to characterize this principle, with a lot of mistakes in sense of legal terminology, but it gives you the feeling where we are heading to. Now let's be more precise in the use of words and in the understanding of what exactly does Article 1 provide for, what exactly does Article 1 require. The text of Article 1.1 is here on the slide. You see, it's an extremely difficult text. It's a lengthy one. And now let's take some time and try read it together. So, with respect to customs duties and charges of any kind imposed on or in connection with importation or exportation, or imposed on the international transfer of payments for imports or exports, and with respect to the methods of levying such duties and charges, and with respect to all rules and formalities in connection with importation and exportation, and with respect to all matters referred to in paragraphs 2 and 4 of Article 3. And here comes the core. Any advantage, favor, privilege, or immunity granted by any contracting party to any product originating in or destined for any other country shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other contracting parties. As I said, not that easy to comprehend it at once from just the reading. It requires some more analysis and some going through the text again and again, unless you manage to understand all the content of it. Well, to begin with, let's split this provision into two parts. And here you may see that the first half of it, starting with the words with respect to, is more on the coverage. So it identifies what are those matters which would fall within the obligation. So this provision is limited in its scope. It does not apply to everything, just all around, whatever you see, it should be MFN. No, there is certain coverage limit which we necessarily need to ensure and comply with. But now let's put aside the coverage, and we will talk about it a little later. Now let's try to understand what is the basic obligation that is here at stake. Any advantage, favor, or privilege, or immunity that is granted by any contracting party to any product originating in or destined for any other country shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other contracting parties. So, any advantage, favor, privilege, or immunity that we give to one product shall be accorded immediately and unconditionally to the like product originating in or destined for all other contracting parties. Now things are more or less clear. So if we give an advantage to a product, to any product, we shall accord immediately and unconditionally this advantage to the like product from all other WTO members, from all other contracting parties. Well, we understand it's the times of the GATT. So before 1995, we would not use the term WTO members, we would say contracting parties. That has already been discussed. The reason behind that there was no international organization, it was just an international agreement, the GATT. So we call members to the GATT contracting parties to the GATT. So here we mean WTO members by the words contracting parties, and we could simplify it once again. Any advantage, favor, privilege, or immunity that we give to any product shall be accorded immediately and unconditionally to the like product originating in or destined for any other WTO member. So you see here it works both with respect to imports and exports, prohibition on the importation, on the importation side, and well, discrimination on the importation side, product originating from, so based on the origin of the product, and also exportation side, destined for, with the view to restrict exports to certain territories. So whenever we give any advantage, favor, or privilege to any product, this same advantage, favor, or privilege shall necessarily be accorded immediately and unconditionally to the like products of all WTO members. So the second half of the provision is more or less clear. Now let's get back to the first part of it, which is essentially the coverage. So it works with respect to customs duties. And this is something you already understand. So we have tariffs, import tariffs, or customs duties, as they are called here. And with respect to those customs duties, with respect to those tariffs, we cannot give preferences to some products, not giving the same preferences to the like products from other WTO members. So imagine my situation of the same pen, which comes from China and from India. And for whatever reason, for instance, let's take the example of the US. US doesn't like China for whatever reason, and the new president wishes to somehow slam a higher tariff on China's pens. And we are not talking of any situations of, say, anti-dumping measures or countervailing duties. We are just wishing to increase the tariff. Let's imagine that the United States has the import tariff binding the maximum level of 20% or 50%, doesn't really matter. So the US will not exceed this binding level. Clearly, they will be within these 50%. But say for a product from China, the customs duty will be 20%, whereas for the product from India, the customs duty will be 5%. Is that permissible under the rules of MFN? No, this is not. With respect to customs duties, if we give a preference, a privilege, an advantage to a product originating from India, we are obliged, under the WTO rules and the MFN provision, we are obliged to give the very same advantage, favor, or privilege to the like product coming from China. So that is why we call it non-discrimination provision with respect to customs duties. So if Article 2 and the schedules limit the maximum level of tariffs, Article 1 prohibits discrimination in the application of those tariffs. So even within these maximum bindings, countries are not free to apply any tariffs they wish if they do not comply with non-discrimination provisions. They cannot discriminate with respect to customs duties, and products coming from one WTO member in sense of customs tariffs, customs duties shall not be treated better than the like products from other WTO members. This is simple. Now let's see what else is covered. Charges of any kind imposed on or in connection with importation or exportation. This is something we also discussed. Those can be various different charges, and clearly those could be, well, charges in connection with importation or exportation. That could be, on the one side, some of these other duties and charges, which will be inscribed in the schedule. Those could be any payments. Those could be even payments in connection with those services which were rendered at the border, which are within Article 22C ambit. You remember that we could introduce some additional charges commensurate with the cost of the services rendered. But here, even those charges could not be discriminatory. If you charge a product from China 100 rubles, you could not charge a product from India 1,000 rubles, or vice versa. There should be necessarily this non-discrimination. If you give an advantage to a product from one country, you shall necessarily give this same advantage to the like product from all other WTO member in connection with charges on imports and exports. Then, charges imposed on the international transfer of payments for imports and exports. This is also an interesting mechanism. You could restrict, say, the maximum minimum currency operations amounts. You could say that if you pay in dollars, you cannot pay more than $100 in one transaction. And clearly that greatly restricts trade with the United States because, well, the United States trades in dollars. And again, charges to the charges in connection with international transfers to the US, to the EU, to Brazil, to India in local currencies may differ. And through these charges, you can again impose effective discrimination because your businesses would have disincentives to trade with these territories. These territories will be at a disadvantage. With respect to methods of levying such duties and charges, and it is also important because we could say that, for instance, if a product comes from territory of, say, Switzerland, we know that the Swiss producers are more or less following the rules. They tend to be compliant with the rules, and therefore they are permitted not to pay import duties immediately at the moment of the importation. They have the period of 6 months following the importation, which our legislator permits them to utilize in order to pay the customs duties. So our customs authorities, for instance, could say, guys, you are from Switzerland, we trust you, so we now put a stamp on your customs declaration, enter the territory, and then you have 6 months to pay. Whereas we could say that, I don't know, well, products from Russia or products from any other country, from Malaysia, products from Myanmar, take any country you like or dislike, they maybe sometimes, or China or India, they are maybe not that reliant, they are not that careful in paying the duties. So we will not give them 6 months more in a way to pay the customs duties after the moment of the importation, but we will on the contrary request them pay all customs duties in advance, have them on the deposit, and we will ensure that unless there is this deposit, this product even doesn't approach our border. And you understand it's a big difference, because if you have 6 more months, you have the money still in your pocket, it is used in your business, whereas once you need to pay it in advance, beforehand, then you are at a disadvantage. So this advantage which we will give to a Swiss product shall also immediately and unconditionally in this way be extended to products originating in or destined for any other WTO members. And then it also applies to all rules and formalities in connection with importation and exportation. This is very important because it's an extremely broad wording. All rules and formalities in connection with importation and exportation. All rules may mean not only formalities or such as customs checks. Well, for instance, there could be news that products coming from the territory of Ukraine would be subject to full-fledged item-by-item customs checks, whereas products, commodities coming from other territories may be subject to selective checks based on the risk assessment mechanisms that are applied by the customs authorities. So this is option one, and it will clearly go contrary to MFN. But then think of it in a more broad perspective. Let's take the example of sanctions against Russia and counter sanctions that were imposed by Russia. So we have some restrictions on the importation of products of certain origin, and whereas the like products of other origins can be imported. Say, cheese from Italy could not be imported, whereas cheese from Uruguay could be imported. So if these two products are alike, if we consider that both are cheeses and they are comparable, then the fact that we are not permitting the importation of one product, whereas permitting the importation of the like other product from any other country, would go contrary to MFN. Same applies actually to sanctions against Russia, though they were more in the field of services, banking services. We are now within the text of the GATT. It does not apply to services, but if you open the GATT Article 2, there will be exactly the same approach towards MFN. Again, you cannot discriminate services and service suppliers based on their origin. So if you say Russian banks cannot get financing, whereas Indian banks or China's banks or Brazilian banks or US banks can get financing, you are discriminating a service supplier, or it can be even a service consumer in our case, based on origin, what is not permitted under Article 2 of the GATT. Yes, again, getting back to what I already said, there can be a justification which we may seek to justify our violation, but with, say, even Russia's counter sanctions on food products, they are a little simpler for us to analyze their products and not services, and we talk more of products in this course. We already understand that it goes contrary to Article 11 because it's the violation of general restriction on general elimination rule on quantitative restrictions, and it goes contrary to MFN most fundamentally because it discriminates between products based on its origin. So yes, necessarily it's a violation of WTO rules. The question would be whether it could be justified through any of the available exceptions, which we will talk about later on. So MFN requirements are there, and you already understood what the story is about. Prohibition of discrimination between foreigners based on their origin, but not foreigners. Let's be specific in wording. We are now talking of products, trade in products. So whenever a product is traded, then it shall not be discriminated against the like product of any other foreign origin. So let's take the example of trade between these three territories. I hope you recognize the flags: Brazil, Argentina, and Peru to the right. So now let's imagine that Brazil and Argentina are trading with Peru and sending there some product, for instance, be that bicycles. And now let's take it at this moment, let's take it for granted that these bicycles are like. We will talk of product likeness in more detail in Article 3, and there will be a big discussion on product likeness, and therefore you will have the feeling of when products could be considered like or not. So we will get back to product likeness in a little while. Now let's move this question aside for a while, and now let's think of these two, say, identical bicycles, which may be produced, say, by the same producer, identical producer. He has a plant in Brazil and in Argentina, and using the same technologies, same inputs, same design, produce a bicycle. But here the bicycle would be considered of origin in Brazil because there has been this either substantial transformation of inputs, or under the rules of origin, whatever the rules of origin would be, the bicycle will be considered originating in Brazil because it was produced in Brazil. The major percent of value added to this bicycle was added on the territory of Brazil. There can be different rules on origin, but here let's think that is the Brazilian bicycle and this is the Argentinian bicycle. Though they look absolutely identical, as you may see on my slide. Now let's think that for whatever political reasons or for whatever trade reasons, or there can be any reasons why Peru may wish to introduce different tariffs as against Brazil and Argentina. So say Argentina's bicycles would be subject to an import duty of 10%, whereas Brazil's bicycles would be identical bicycles, would be subject to an import duty of 20%. Think of it, and to make it even more complex, I could add one more caveat. The bound rate in Chile, the bound rate in Peru is 30%. So Peru is not exceeding its bound rate under the schedule. There is no formal violation of the schedule under Article 2. However, think of this in the context of Article 1. Is there a violation in this situation? And the answer is affirmative. Yes, there is clearly a violation of MFN, because even though not exceeding the bound rate, Peru is charging like bicycles from Brazil higher import duties than it is charging like bicycles from Argentina. So this is exactly the type of matters which are not permitted under Article 1. So Article 1 is not about these bound tariff levels. It's much broader in scope, and it prohibits discrimination. That is important. So this is one of the two major pillars of the non-discrimination treatment under the WTO rules. And here, what is most important is that Brazil, in this case, if it has not received treatment, would be permitted to go to the WTO, have recourse to Article 1, and if it is established, then the moment it is established that there is a violation, this treatment of 10% shall be accorded immediately and unconditionally to Brazil. There will be no need to any additional amendment of domestic law from the international law perspective, because it says that whenever a privilege is given to a product from country A, to a product from country A, this same privilege shall be immediately and unconditionally granted to the like product from country B. So this is relatively simple and more or less understandable, I guess. Now let's make this story a little more tricky. I replace Argentina with a different territory, and let's find out if it makes any difference. Do you recognize the flag? That is the flag of the Islamic Republic of Iran. And now let's think about this from the perspective of Iran. Why have I chosen Iran? Does it make any difference? Well, I hope if you were following my lecture on membership, you understand the reasons why Iran was chosen. Because Iran is one of the major economies which are still not within the WTO family. So Iran is not a member. Now let's think of this situation. We give some preference to a product from a non-member, and imagine again we are talking of the like product, not to introduce unnecessary complexities in the picture now. So these are the two identical products, one imported from Iran, one from Brazil, and product from Brazil is receiving 20% treatment within the bound rate. Product from Iran is receiving a 10% treatment, though again, Iran is not subject to WTO rules, and Iran therefore is not actually caring much about those bound rates, but it receives this privilege of 10%. This is far more complicated. And again, take a minute, put this video on pause for a while, and think whether it will be a violation or not, because the answer to this question is far not that straightforward. However, in order to respond to this question, you can look as long as you wish, but if you do not really read the text once again, you will not be able to answer. All legal answers shall always be found in legal texts. We cannot make any assessment based on our feelings, emotions, intuition, because intuition can very often go against us. So on the one hand, you may have the feeling that Iran is a non-member, is not a member, so as long as he's outside of the system, he's outside of MFN, these MFN rules do not at all somehow bother the existence of Iran. So whatever you do with Iran is outside the WTO. Whereas everything that is within the WTO should be MFN compliant. You cannot discriminate products from WTO members based on their origin. Now let's find out if this reading is there in Article 1 of the GATT. We get back to the text. Let's read it once again. Now we don't need the introductory part, the coverage. We understand that we are now talking of customs duties, so we are clearly within the coverage. Now let's go to the second half of the provision, which is the core obligation. Any advantage, favor, or privilege granted by any contracting party to any product originating in or destined for any other country shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other contracting parties. Here, notice the difference. We say in one occasion, any other country, and in the second half, we say territories of all other contracting parties. It makes a big difference. Read it once again. Any advantage that we give to any product originating in any other country shall be accorded immediately and unconditionally to the like product originating in territories of all other contracting parties. So getting back to my situation of Iran, we need to understand that this situation will still be a violation of the WTO MFN rule. Why so? Because here the idea is that any country receiving the benefit, well, in case there is any country, any product from any country that gets the benefit, this same benefit will be given to all other WTO members, to all products from all other WTO members. And it doesn't work in the opposite direction. So if you give preferences to China or to India or to Russia or to the EU, you are not obliged to give it to Iran, because again, Iran did not become a WTO member. He does not get the benefit of MFN treatment. Whereas if you are giving a preference to a product from Iran, Iraq, or any other territory that is not yet WTO member, you are obliged to extend it to the WTO members. And hence is the name of the provision. You remember it is called Most Favored Nation Treatment. So what is the concept behind it? The concept is simple. If you are a WTO member, if you are within the GATT family, you are always the most favored nation. There will be no other territory, no other country within the WTO or outside the WTO that will get more benefits than you will get. You always become best treated. You are always the most favored nation treatment. There is no other nation that is more favorably treated. Therefore, the name is pretty understandable if you feel this concept in the second half of the provision. If you're within the WTO, you always get the best treatment. And it would not matter much if we are talking of other WTO members or not WTO members. Doesn't really influence. So here the question is now how to resolve my case with Iran. With Iran, the situation is simple. If you give preferences to Iran, then you need to give them to all other WTO members. The idea behind that is also really a clever one, because the WTO was intended and the GATT was intended to be a closed club, and there should be incentives to enter the WTO. And MFN is one of the huge incentives to be a WTO member. Why so? Because if you are within the club, you always get the best treatment. If you are outside of the club, you can always be discriminated against, and you have no protection. There are no other international rules that will protect you, well, unless you enter in some rules bilaterally. So there are no other international rules that would protect you from discrimination. And that is why countries have the incentive to enter the WTO in order to become WTO members, to avoid the discrimination of their products. So if we talk of Iran, would it be a violation to say, Iran, you pay 30% and Brazil, you pay 20%? In the context of what we just read, in the context of MFN provision, no, it will not be a violation. Iran is not a member. No one promised Iran anything. So here, Peru can just say, Iran, I can apply any tariff which I find necessary and discriminate your product against products from, say, Brazil. Could we even do it this way if Iran would be subject to a 40% customs duty? The answer again, yes, that could be done. Why so? Iran is not a member. Iran does not enjoy the benefits of the schedules, of the bound rates. So Iran can be subject to any customs duty of any sort, any height, and there will be no rules, well, unless Iran entered into some bilateral agreements that could be there. But on the global scale, there are no rules that would prohibit discrimination against Iran, because Iran is not yet a WTO member. So the MFN provision is one of the big incentives to enter the WTO. Once you are there, you are always treated best. There will be no other nation treated better than you are. And if there is any advantage you do not get, that product from any source obtains, then this advantage, privilege, or immunity shall be immediately and unconditionally extended to the products of your territory. And then to complete the story, I turn it around. Could Iran introduce such a discrimination? Could Iran say, not being a WTO member, Brazil pays 20%, Peru pays 40%? Well, unless there are other rules that would restrict Iran from doing that, any bilateral agreements or domestic legislation in Iran, Iran is free to do anything it wishes. So Iran is not bound by WTO rules. Iran has no binding schedules, at least now, and therefore Iran could also introduce any tariffs it wishes in sense of their amount, whereas in sense of discrimination, again, Iran didn't promise anyone anything. So Iran is free to determine any tariffs on any products and discriminate products based on their origin, unless there are some other international rules which will apply to Iran that you may need to check. But on the global scale, there is nothing that would restrict Iran from doing that. So if I were to try summarize the legal test of Article 1 provisions, let's see what the appellate body in EC Seal Products case told us. We will talk about this case a little later when we talk of Article 20 in more detail, because it's an interesting one. And Article 1 actually has been interpreted to consist of 4 elements. In order to establish a violation, we need to go through these 4 elements analysis. And each of those elements is necessary to be established. They are cumulative. So we need to, first of all, ensure that the measure at issue, which we will be considering, that a rule that has been introduced by the domestic legislator or the decision of the national customs authorities or any other authorities, to begin with, fall within the scope of Article 1. So we will need to go back to the text and read again if it's within one of those customs duties and charges, methods of levying such duties, formalities in connection with importation or exportation, and ensure that this is what we fall within. This is understood. This is something we discussed. And you just go once again, read the provision and make sure that you fall within this text. Second, we need to ensure that the 2 products are like products. And then this is something we will talk in more detail a little later. Now let's put it aside. Product likeness is a legal concept, and there is a certain interpretation that has been provided to the term like products, which we will talk about in due course. Third, you need to ensure that the measure which you are concerned with confers an advantage, favor, privilege, or immunity. So you need to make sure that there is some advantage, favor, privilege, or immunity. Well, any of these words are very similar, but you understand they were included so that to embrace all possible situations and to avoid any misinterpretation, to make sure that the scope of the provision is as broad as possible. And then these advantage, favor, privilege, or immunity has not been extended immediately and unconditionally to the like products. This is also something that you need to make sure. You need to see that indeed there was no effect of giving the benefit of these advantages to the like products. If they have not been extended, then we are in the situation of the violation of MFN. A few words about advantages, favors, immunities. How do we understand that? The panel in EC Banana's case was telling that this advantage is any more favorable import opportunity that would affect the commercial relation to the detriment of the product of one origin. And therefore, it is very broad in scope. Any more favorable import opportunities would constitute an advantage. Don't try to be here excessively formalistic. The reading of the provision has been so that to introduce all possible advantages that could be thought of. Well, for example, the allocation of tariff rate quotas in the very same EC Bananas 3 report. Tariff rate quotas can be allocated in a discriminatory fashion, and we talked about the allocation of tariff rate quotas in detail in one of the previous lectures. And the allocation of tariff rate quotas is also subject to MFN provisions. It is an advantage. If you give the right to import at a lower duty, it's an advantage. Clearly, it will be an advantage. The right to file advance import declarations, which is available to some foreign products and not available to the other foreign products, which will greatly simplify all the crossing the border. The Colombia ports of entry case was exactly about this. Well, one of the matters raised there was about MFN violations, given that advantages were not granted to all other WTO members, to all other products from WTO members. Easier access or at all access to certification procedures, which are also necessary for you to import the product to secure compliance with the domestic rules on, say, safety, sanitary rules, or those could be rules on some technical requirements, technical protection. So the availability of certification procedures to only some products of foreign origin, be it the euro or de facto, doesn't matter. Article 1 clearly covers both measures which are de jure or de facto discriminatory. Therefore, effectively restricting access to certification procedures to products of a particular origin would be also contrary to Article 1. And even individual dumping margins for some countries, whereas the products coming from other WTO members will be subject to country-wide margins, may well go contrary to Article 1. So you see, it's an extremely broad, in sense of coverage provision. Advantages could be understood very broadly. Any more favorable import opportunities. So how do you make the distinction between advantages, favors, privileges, immunities? I'm not even going to dive in these terminological differences, though there is some practice discussing it, some jurisprudence discussing these differences. But for you, it is important to understand that this implies any more favorable import or export opportunities which you are giving to a product based on its origin, what is not permissible under Article 2 of the GATT. Then as for immediately and unconditionally provision, what does it mean? Same EC seal products appellate body. What is important, we need to understand that the rule prohibits any conditions that have the detrimental impact on the competitive opportunities. It is not meant to imply that no conditions on imports could be introduced. Conditions on import can be introduced, and one of the conditions, for instance, would be the need to provide, say, sanitary certificates or certificates of compliance with domestic technical regulations. Those are the requirements which will be necessary, and there can be these conditions on imports. Even payment of a customs duty is in a way a condition on import or export. However, what Article 1 prohibits is the imposition of such conditions that have detrimental impact on competitive opportunities. So if we talk of influencing competitive opportunities through those conditions, then that would not be possible under Article 1. But you can still introduce some, as the appellate body says, regulatory distinctions to be drawn between imported products, provided that such distinctions do not result in a detrimental impact on the competitive opportunities. So, for instance, products from one country can be more vulnerable to a disease, for instance, or a crop which only exists, say, in Latin America or in South America. And there is no need to make additional checks whether this, I'm sorry, not a crop, I mean an insect. Yes, so in crops there can be insects, and if those insects only live, say, in South America, then there is no need to check products coming from Australia, Africa, or Europe, or Asia, and request for a certificate that would demonstrate the freedom of your product, yes, from this insect, that your product has not been somehow infected by a disease, or there is no risk of this insect coming into the territory. So that could only be applied, it will be a conditional import, and it will be applied to a group of products coming from a particular region, but it will be based on the legitimate regulatory distinction, and it will not result in the detrimental impact on the competitive opportunities for the like products. Again, if we treat these two products like, given that there is this disease or insect which may be there. As I said, MFN provision is extremely fundamental for WTO rules, and MFN is not only within the GATT Article 1, MFN could be found in many other provisions of the WTO agreements. This is just the list I'm introducing for your information. There are MFN rules which are available in other GATT provisions. We mentioned Article 13 already, administration of quotas and tariff rate quotas, and we said that there is the underlying non-discrimination obligation, effectively MFN obligation. I will now say MFN just to identify this non-discrimination rule that prohibits discrimination between foreign products when we compare foreign products as against each other. There are rules on MFN which have been reflected in Article 20, general exceptions, its introductory part, the so-called chapeau. We will talk about Article 20 in more detail coming closer to the end of this course. There are rules on non-discrimination in Article 3.7, the so-called mixing requirements, which also there you could check it. Film quotas, freedom of transit, Articles 4 and 5, same rules on MFN treatment. Again, MFN is so fundamental that you can find it in all other Annex 1 B and C agreements, well, meaning the GATT and the TRIPS. With respect to trade and services, the same MFN rules apply. You cannot discriminate services and service providers based on their origin. And same applies to TRIPS. You cannot give some preferences to the protection of intellectual property from one WTO member and not give the same, or from any other country, and not give the same protection of intellectual property that belongs to intellectual property right holder from the other WTO member. So this is extremely fundamental. And even in the specific agreements in Annex 1A, goods agreements, TBT, SPS, safeguards, import licensing, rules of origin, pre-shipment inspection rules, you will find obligations to provide MFN. So it's indeed extremely fundamental. It's indeed most important, well, one of the most important provisions of the GATT, and it is indeed very widely interpreted and very often applied in dispute settlement, because MFN violations, most often de facto, can be, on the one hand, demonstrated. On the other hand, they are really most unpleasant for WTO members. Therefore, this provision has been abundantly applied in practice. Now let's talk of exceptions. As always, we start with exceptions once we are through with the underlying principles. If you go to the text of Article 1, you may be tempted to read out exceptions from the second or third part of Article 1. And those exceptions do indeed exist in the text of the GATT. No one crossed them out. And sometimes I got these answers during the exams, that what are the exceptions to MFN, and then I was told something about, well, the country is formerly part of the Ottoman Empire, preferences in force between US and Cuba, as if nothing happened since 1947 in trade relations between US and Cuba. So most of these provisions, which are here in Article 1.2, Article 1.3, those are by today mostly outdated. So we don't use those provisions any longer. I'm not going to comment on it, though, again, situations may occur when it happens, but it is so rare that there is no need for us to focus on these exceptions now. Read it once and keep in mind that this text dates back to 1947. Therefore, it shall be perceived in that historical context. Then there is a second exception, which is the one we are going to talk about today, and it will be the last part of our lecture that I'm going to cover. It is the so-called enabling clause. It is the document, which we'll talk about in more detail, which gives certain flexibilities to developing countries, and these developing countries have the right to violate MFN, and there are provisions for other WTO members to go around MFN if they are trying to support the developing countries. So this dates back to 1970s. It was the time when this development agenda was in blossom. There was even an additional chapter on trade and development added to the original text of the GATT, which you may also find there. And this decision also was made part of the GATT ambit because there was a common understanding there is a need to stimulate development through trade mechanism. And then there is a third fundamental important exception, which we will talk about in detail in the next lecture. It is regional trade agreements, so-called free trade areas and customs unions. Well, take the example of EU. You all have traveled, I guess most of you have traveled from one territory of the EU to the other territory of the EU. You see there are no borders. You see there are no custom checks. Products are traded freely. They are not subject to customs duties. So a product from France can be sent to, say, Italy or Germany without any customs duties, whereas the product from Russia could not be sent to Italy or Germany without paying customs duties, well, in most cases, unless it's a zero customs duty and the applicable rate. So those are exceptions, free trade areas, customs unions, but we will talk about them in more detail in the next lecture. So now for today, our plan is to talk about the enabling clause. And the enabling clause is actually the decision of the GATT contracting parties that dates back to the 28th November 1979. It is extremely difficult to find on internet. You just type enabling clause on Google. The first link leading you to the WTO website will give you the text of the enabling clause. It's a short document, a 3-page document, maybe 4-page, don't remember. It's a very short document. And this document is not officially called the enabling clause. That's the unofficial name of it. But we all label it in this fashion, and everyone knows it under this name. However, the official name is differential and more favorable treatment, reciprocity, and fuller participation of developing countries. 28th November 1979. So this document was also made part of the modern WTO system through the incorporation in GATT 1994. And this is exactly the document that gives preferences to developing countries. Whenever you face a need to analyze preferences to developing countries, I highly invite you to go and check the enabling clause because it may give you some additional advantages in that sense. So the enabling clause, here I give you just a part of it. It's not the whole text of it clear, but these are the most important parts, Articles 1 and 2, which we will talk about now in more detail. So as I said, it's the decision of the GATT contracting parties. Now it has the value of an international agreement of the WTO members of the same value as GATT 1994. and it permits the derogations from the MFN treatment in favor of developing countries. So what are those derogations that are possible under the enabling clause? There are actually 4 parts in Article 2 of the enabling clause. We will now focus on the first one, but keep in mind that the others are also there, potentially available. They are not that frequently applied, and I do not mean to talk about that in more detail. There is a separate course on regional trade integration, which requires a more in-depth analysis of the enabling clause here. There is no need to go that far in detail for our overall bird eye view, but keep in mind that to begin with, the enabling clause permits tariff preferences to developing countries. So it permits to provide more preferable tariffs, provide advantages, privileges, immunities with respect to customs duties in cases of imports from developing countries, if a product originates from a developing country. Then it also gives some flexibilities on non-tariff measures for developing countries. It also permits global and regional arrangements among developing countries in goods trade. We will talk about this point 3 in the next lecture on regional trade agreements, and it also provides for the right to derogate from Article 1 from MFN for general or specific measures in favor of developing countries. So I'm not going to talk about articles about 2 and 4 because they are of less importance and they are less frequently applied. However, for your basic understanding of international trade regulations, especially point 1 is essential, because this is something you may face when trading in modern world very often. And these tariff preferences do really influence the decisions of many companies on their investment and incorporations. But let me give you the examples. What is this? What is we are talking about? The tariff preferences to developing countries are now present in most national legislations. Well, there is a system of tariff preferences to developing countries that has been implemented by the European Union, for instance. And here is the information from the European Commission website, how they explain their system of GSP, Generalized Scheme of Preferences. So this generalized scheme of preferences consists of actually 3 tiers, 3 groups of countries that do get certain benefits. On the one hand, there is the so-called standard GDP for low or lower middle income countries, and products coming from these countries to the territory of the EU are eligible for partial or full removal of customs duties on about 2/3 of tariff lines. So not all products are subject to GSP reductions. Many products are not subject to reductions under the GSP. However, this standard GSP does permit the reduction of tariffs. So if your product comes from a developing country, then you will pay less at the border. And it makes a lot of sense then for businesses to go and invest in those territories, to produce in those territories, because then when bringing a product to the territory of the EU, you can save on customs duties and you can become more competitive. And this is something we really don't think of that easily. But I remember talking to head of legal of Puma. You know, Puma is a huge brand producing sports apparel, sportswear, shoes, well, anything related to sports. It's a huge world brand which is known internationally. And Puma, when there was a change in the GSP European regulation, and Vietnam was partly removed from the scheme, whereas Cambodia was not, and Cambodia, as least developed country, gains more benefits, even relocated the production facilities from Vietnam to Cambodia in order to save